The High Court in Pretoria has declared the blocking of IDs by the Department of Home Affairs unjust. The application was brought by Lawyers for Human Rights and other civil society organizations on behalf of over 100 affected people. Most of the affected were as a result of duplicate ID numbers that the department blocked. Thandeka, Chauke, Stateless project manager at Lawyers for Human Rights. She is the Stateless project manager. Thank you very much, ma'am, for your time this afternoon. And so the judge hearing this matter found that the blocking of those IDs without following any just administrative procedure constituted a mischief. Perhaps remind us why you took this case to court.
Thank you for having me, Judu. So essentially what ID blocking is that it is an administrative tool that the Department of Home Affairs has employed in order to maintain the integrity and accuracy of the National Population Register. So essentially when an ID is blocked, a marker is placed against that person's ID number in the National Population Register, and the effect of that marker is to block the ID, meaning that the ID is essentially rendered useless. So you cannot use that ID for anything like banking, like applying for a passport, a driver's license, and all other, instances where you might be required to produce identification. And in the last 5 years, Lawyers for Human Rights has encountered over 500 of such cases with people whose IDs had been blocked. In all of these cases, these people would have discovered this almost by mistake, while trying to access another service, and they informed that your ID is blocked, visit the Department of Home Affairs to rectify the issue. And then what would happen is that these people would remain with the issue for several months or years before even getting a resolution, because it became apparent that the Department of Home Affairs didn't really have a transparent process in terms of rectifying blocked IDs. Even in terms of criteria for the blocked IDs, what we had observed from the cases we saw was that the ID could be blocked for a variety of reasons, such as those that are suspected of fraud or misrepresentation, but also those that are just affected by an administrative error that is likely to have been made by a Home Affairs official. So, for instance, if your name has been spelled wrong, if you've been assigned the wrong gender marker on your ID, or if your ID has been duplicated against another person, such that it's one person that's sharing the same ID number or one person that has been assigned multiple ID numbers.
Given that the Department of Home Affairs was objecting to this, what was their argument, rather?
So the department has indicated what we agree is a genuine interest in maintaining the accuracy of the National Population Register as the main reason of using ID blocking. But the contention is that ID blocking is administrative action at the end of the day, and of course there are laws and processes that must apply in terms of Home Affairs taking action. So the one issue of concern was that there wasn't empowering legislation that gives Home Affairs the authority to block IDs in the manner that it was doing so. And then to add to that is the issue of the defective administrative process that they were following. So Home Affairs' main argument is that this issue of ID blocking is used basically as a measure of security and to maintain the accuracy of the National Population Register.
And so what was the declaration? We understand that this must be rectified within 90 days. And when it comes to the removal for minor children whose parents' status as South African citizens or permanent residents has not been finally revoked, what happens with that?
Yes. So essentially what the court has ordered is that the Lawyers for Human Rights must provide Home Affairs with the list of affected blocked ID clients that we currently have. And within 90 days, the department needs to resolve all those cases. And there's also been a measure put in place to say that if any of the cases have been flagged as potential security risks, then the department must approach a court in order to get an order that allows them to retain the block in respect of those IDs. And then in respect of children, you are quite correct. The department has been ordered to immediately lift any blocks that have been implemented against the ID numbers of children. In addition to that, the court has explicitly noted that no child may be denied their own birth certificate or ID based on a blockage or investigation into the status of their parent, which is very important because children are, they're also self-standing individuals with their own rights, and it can't be in the best interest of the child to simply be deprived of documentation based on action that has been taken against the parents.
Any indication that the department will appeal?
We have not received any indication of an appeal. We strongly urge the department, in fact, to swiftly implement this court judgment, given that it has conceded itself that there is no law that allows them to block IDs. By the time we had the hearing in September, they had also indicated that out of 2.5 million IDs, 1.8 had since been unblocked, but 700,000 remained blocked. So we are looking forward to the department implementing this judgment very quickly in order for people to, have their dignity restored, have their lives restored, and to be able to register for upcoming elections, because that's one of the implications of having a blocked ID, is that you won't be able to vote, which is one of the most important rights as a citizen of South Africa.
Why did it have to head to the courts, ma'am? Does this mean that engagements with the department had failed, and hence your last resort was to approach the courts?
Precisely. So we had first managed to trace the issue of ID blocking as far back as 2010. And at that point, we would try to resolve individual cases with Home Affairs by writing to them to highlight that this had happened to a particular client, and to request reasons for that action, and to request that they rectify the ID. And in the beginning days, we would get, timeliest responses and resolution to the cases. But as the years went on, we started noticing that Home Affairs was less responsive to NHR, less responsive to clients, and there was simply a lack of clarity as to what was happening with this issue of ID blocking. Even at that point in 2010, I think there were at least 500,000 cases, which soon grew to close to 1 million in 2020. And then, of course, now, as I mentioned, that in 2023, we discovered that number had doubled to 2.5 million. So it was just a problem that the department clearly had failed to resolve within a reasonable time. We had made efforts to write to the department to try and find a resolution, but of course nothing was forthcoming, which led us to approach the court for the relevant relief.
Thank you so much for your time this afternoon. Thandeka Chauke, Stateless Project Manager at Lawyers for Human Rights.